So, I'll change the section now. So we've gone from the Building Act to code compliance. How do we comply with the building code? So remember, we've got the Act, we've got the regulations, and then we've got the code that sits at the bottom. And so our job as people in the construction industry to comply with the building code. With each technical clause, requirements are explained in 3 levels, which are just what I've just said. Objective, social objectives of the Building Act, the functional requirements, what functions the building must perform, and the performance criteria that must be achieved. By meeting the performance criteria, all the others are met. So if we look at that in more detail, we'll take an example for E2 of the building code, external moisture. The objective is the provision to So walls and floors structured in close proximity to the ground must not absorb or transmit moisture. So these are the performance requirements. It still doesn't tell you how. Still doesn't tell you how. It tells you what you have to achieve. It doesn't tell you how. That's why you need to go to the seminar. It costs $99 though, I've just looked it up. So there's an address there where you can download it. I tried this last time, the links don't work here, but those addresses you could copy and paste them into the search engine and they'll come up. Copy of the New Zealand Building Code. And also I'd recommend you download, at least have a look at this publication here, which is a summary. Okay, so MB's New Zealand Building Code Handbook, it's worth having a look at. So still in terms of compliance, we now, having got the building code in place, we have to apply that to a building consent. We need approval to build our building by the issuing of a building consent. So the building code sets out the levels of performance that must be achieved, such as weather tightness, durability, and thermal performance. When you apply for a building consent, you need to demonstrate how that performance is going to be achieved. When you make an application to the council, you have to show them how you're going to meet the building code. And how do you do that? You do that with plans, drawings. You do that with specifications, describing the work. You do it with certificates, a whole lot of certificates, okay, from the various manufacturers, outlining the performance of their material that they're supplying, and producer statements. So it might be, the simplest one might be an engineer writes a producer statement saying that the structure has been designed in accordance with the proper design codes. So this is how this combination of documents is a demonstration of how you're going to meet the building code. And you submit that to the council. The Building Consent Authority, BCA, otherwise known as the council, okay, will assess that information. And they will determine whether your proposal meets the building code, if it's undertaken as you're showing it. Even if you, and I said this before, even if you don't need a building consent, okay, for a small building, 20 square metre building, you still need to comply with the code. So the first, an early step in meeting compliance to the building code is the obligation to get a building consent. A building consent outlines your proposal of how you're going to build. Most clauses in the building code have acceptable solutions, thank goodness, or verification methods. Okay, if you remember, you go back to there, that's the building code. It tells you what you have to do, it doesn't tell you how. It doesn't tell you how. There are acceptable solutions of how you do this. And that describes how the performance requirements of a particular clause can be met. Acceptable solutions are not mandatory. You don't have to follow those. But if you do, your building consent will be accepted. Meeting cited standards provides a means of compliance with the building code. For example, a code, Timber Framing Code 3604, is a means of meeting the structural requirements. The building code says that the building has to stand up. 3604 describes how a timber frame building will do that. And so in our pyramid of requirements, the Building Act, the Building Code, down here we have verification methods and standards. Verification methods are acceptable solutions, whole range of acceptable solutions, and cited standards, 3604. So that's one way of ensuring that your building will get a building consent and will comply. The alternative to solution and design standards, using expert opinion. This is more difficult to prove with the council. If you're not using acceptable standards, but you're demonstrating alternative solutions using experts, the council can in fact challenge the expertise of the person that's saying this is okay. But it's an alternative method. So if you don't want to use an acceptable solution, you can go back to first principles with an alternative solution and with other standards and design from first principles. But the council still has to be satisfied, and that's much more difficult to get a building consent through that way than using acceptable solutions. So, authorisation to build. You've made the application for a building consent, you've put all this detail in, you've quoted all of these acceptable solutions, you've demonstrated how you're going to put the building together. A building consent is the council's written authorisation to carry out the building work, provided it is completed in accordance with the plans and specifications. So you can't get a building consent and then just build the building any way you like. Once you have a building consent, you are absolutely committed to building that building how the drawings and specification describe it. And you can't make alterations unless you discuss that with the council, and you'll have to submit more documentation. So the building consent is the authorisation for doing the work. It's required, I've said this, for almost any building work, and if you don't start within 12 months of the issue of the building consent, it will lapse. It will no longer apply. So you must start within 12 months. Building inspections. You've now got the building consent, you've started work. Remember, this job has to comply with the building code. And so how is that done? The building consent issued by the council will list the stages at which you will need to call for inspections of the work. When I started out in construction, if we built a house, I think there were three inspections in my day. Pre-concrete, okay, so they could check the reinforcing steel. Pre-lining inspection, so they could check the timber framing and perhaps the insulation. And the final check was a final completion. They went round and made sure everything was finished. 3 inspections. How many inspections now? Heaps. Heaps and heaps. 12, 15, 20 if you get something wrong. You have to have a re-inspection. So many inspections are required. This is because the council is very, very risk averse. Remember, every council in New Zealand has come through the leaky home period. Okay, and if I had a leaky home, how do I recover my loss? Oh, I go after the architect. Well, the architect's got no money, or go after the builder. Oh, the builder's gone bankrupt. The last person standing, or the last organisation standing, has been the councils. Okay, and they've paid heaps and heaps of money out. All right, because they were deemed to be responsible for the leaky house. They didn't do. They only did 3 inspections. They should have done 10. So they were responsible for the leaky house, and they had what we call deep pockets. They had plenty of money. So if you own a property, you and I, we are still paying that right through our rates through the council. So the council have become very, very risk averse. They are managing this risk very closely. So very, very detailed drawings and very, very close inspections. So this is a response, a very direct response to the leaky homes that occurred in New Zealand. So, as I've said many times, the work must be completed as described in the building consent, and the council must be satisfied on reasonable grounds undertaken by inspection that the building work under the building consent complies with the building consent as issued. Okay, so you must build it as you said you were going to build it, and they must be satisfied. It is the building owner's responsibility to get the council sign-off. The ultimate responsibility is the building owner, not you as the contractor. Code compliance certificate. This is evidence that the building is now built according to the code. Code compliance certificate is a formal statement saying that the building work carried out under building consent complies with the building code. Code compliance, CCC. The owner must apply for the Code of Compliance certificate after all work set out in the building consent approval has been completed. Applications for Code Compliance certificates must include certificates by licensed building practitioners. So every licensed building practitioner must provide the owner with a record of building work that state what restricted building work they carried out and supervised. So that's part of the code compliance submission. It's the responsibility of all trade licensed building practitioners to provide records of their work to the owner or holder of the building consent. So that's a code compliance. It's a formal process and requires significant documentation. Council must decide within 2 years to issue a code compliance certificate. So there have been cases where the council has refused for some reason. They're not happy with something. But they are required to say yes or no within 2 years. So I know of personal friends who don't have a code compliance certificate because there was a dispute with the council around evidence. Okay, so the council has a period of time in which to issue the certificate. Code of compliance certificate will be issued by the council. So there we go. We've got the building code as a framework. We've got all these requirements. We've got acceptable solutions. We've put in a building consent with all the plans, specifications and producer statements and all the rest. We've got a building consent issued. We've undertaken the construction work. We've undertaken all these inspections. We've had the council issue a building consent, a building a completion certificate. Okay, along the way, there are things that can happen, and I've labelled it offences. So, as a professional, a building professional, failing to comply with the requirement of building work must be carried out in accordance with the building consent. So if you don't build as per the consent, you've committed an offence. Now this is a statutory offence. This is not common law. This is against statutory law, where there are penalties set out. It's very clear. Failing to comply with any notice to fix. So, building inspector comes on, inspects your project and issues a notice to fix. You carry on, ignore the notice. Okay, you've committed an offence under the Building Act. Licensed building practitioners who refuse to provide a record of building work without good reason are liable for disciplinary action through the Building Practitioners Board. So there's a whole disciplinary regime that sits in behind the licensed building practitioners scheme. So there is a board, there's the registrar, and then there's a board who makes decisions on your performance. Ultimately, they can deregister you. And one of the offences is the refusal to issue a record of building work. The only reason that a licensed building practitioner doesn't have to issue a record of building work is if they're dead. Or if they've got, oops, where's my light? Somewhere. Serious medical condition. Oh, I've gone overseas or done something else. That's no reason you have to issue a record of learning. It's an offence for a property developer or builder to sell a house without a code compliance. So if you are the builder and acting as a developer, you can't sell the house without a code compliance. That's an offence under the statute law. It's an offence to use a public building that doesn't have a building consent or code compliance. A public building has to have a code compliance certificate. It's an offence to use it without one. So that's just an example. If you look at the building code, there's a whole page of offences or things that you can do wrong, okay, for which there are fines that can be applied. So the practice is comply with the building code. This is about your reputation. It's about your status as a licensed building practitioner, okay, to maintain compliance. Okay, that's the building code. Very, very quickly. There are two more sections that I'd like to get through. One is on insurance, and the second one is on employment law and employment agreements. So the first one, insurance. So if you're acting as a builder, you must insure yourself against risk. Because what the owner is doing, if I'm the owner, I am putting all of the construction risk onto you as the builder. Okay, I'm not taking any responsibility for any of the risk. It's all your problem, mate. So the first thing that the builder has to do is assess that risk. They have to do a risk assessment. And then having done the risk assessment, they've identified what all the risks are. They should then price that into their bid or into their tender. So there's a risk of this happening. It may or may not happen. So will it happen? Won't it happen? The other criteria is, if it does happen, how significant or how serious is it? Is it minor or is it major? So those are the two criteria: the probability of the risk happening and the significance of the risk happening. And you as a contractor should be assessing all the risk in your project. And the first thing you do is you put in a financial factor to cover that risk. It may or may not happen, but you are financially covered. So that's the first thing. The problem at the moment, why so many construction companies, even large companies, like since I saw you last, was it Arrow? Gone. Why? Because they haven't been doing a proper risk assessment. They are taking on a huge amount of construction risk and they are completely unaware of it and they are not pricing it. And the biggest risk that they're taking on, there are two things. One is labour and the other is time. They're not allowing enough time and they haven't sourced the labour. They are delivering the buildings late. And that is essentially the whole common theme of all of these building company collapses. They are not managing risk. So that's the first thing you've got to do. Identify risk and manage it and allow for it in terms of your bid. The second thing that you have to do is insure yourself. As a contractor, you have to take on some insurance. So just as the owner is shifting all the construction risk onto you as the builder, you've done a proper assessment so you know what the risks are and you've got it in your price, but then you are also managing your risk by shifting it onto an insurance company. Why do we have insurance? Stuff happens. That was last year in Florida. You might have seen it in the media. Bridge collapsed. Major. 8 cars or something trapped underneath it, that one there. But all I've got here is a whole lot of crane collapses. Here the structure's fallen down. Remember that when you're building a building, it gets progressively stronger as you add more and more structure. So when you start, it doesn't have the design strength of the final structure. And we use temporary work or false work to hold it up. Okay? In this particular case, it was a failure of that temporary work to support the structure. If the bridge had been completed, it would have been structurally fine. So as you build things, it gets progressively stronger and stronger. And the reverse happens when you're demolishing buildings. As you're demolishing buildings, they get weaker and weaker and weaker. Okay? And accidents can happen. There is no good reason for this crane collapse. That shouldn't happen. That's just essentially human error. They overloaded the crane. They didn't put it on a decent foundation. Okay? Overloading cranes, all the stuff's automatic. They know when the crane is overloaded. Okay, but these things happen. And in your risk assessment, you may not have anticipated that the crane was going to fall over. It was a plant risk as one risk that you should be identified. But you've transferred this risk onto your insurance company. So you may not have the capital structure. You may not be able to withstand a claim against you for these sorts of losses. So it's like I'm the owner. It's my building. I haven't contributed to this collapse. I haven't done anything. You have. It's your problem. I'm going to sue you. All right, and I'm going to sue you for $10 million. Have you got $10 million? Nope. Oh, you have? Yeah. Okay, let's say 100 million. Okay. So, in the case of Mainzeal, it was 110 million. Okay. And they had no money. All right, so often the capital structure, how much money sits within the company, is quite low. A construction company depends on one thing to keep surviving, and that is cash flow. Cash flow. They need the money going through their business because they've got no money themselves. And of course, that's worse if you've got a property developer. Right? A property developer will drive the nice car, wear the white shoes, but trust me, they have got no money. All right? They're using everyone else's money. So when something happens, don't go to the property developer because they've got no cash. So that's a problem with construction companies. They are undercapitalised. They don't have enough money. They are dependent entirely on cash flow. So when something serious happens, the only way to manage this is through insurance. So there are many risks in a construction project. The majority of the risks are usually anticipated and priced by the contractor into the construction phase. These are things I've just said. Insurance is a way of managing risks. When a contractor buys insurance, they transfer the cost of a potential loss to the insurance company in exchange for a fee or a premium. So they're transferring that risk. They pay a small amount of money, comparatively. Insurance companies combine all those premiums from all their clients, invest the funds securely, and they can pay out when there is a claim, hopefully. When you've got major claims like Christchurch earthquake, it tested the insurance industry. They too started to run out of money, okay, for very, very large claims. So, insurance, there are some contractual obligations generally within your contract under the general or special conditions of contract. This is seen by the parties as a known risk, these things. How can I get the project finished? Remember I said last time about progress payments, it's not about the value of the work done, it's about the value of the work to complete. That's important to the owner. I have to retain enough money to complete my project. If something happens, an accident happens, I want enough money to be able to finish my project. Okay, so that's generally expressed in the contract. Insurance policy is a contract, so the usual contract laws apply in terms of the actual policy. A contractor seeking insurance completes a proposal form. So you fill out a proposal form to the company and saying, I want this type of insurance for this project. Each company has their own standard form. Contractor will sign the proposal, and so by signing, they are offering to accept insurance on the basis of the proposal. So it's a contract, offer and acceptance. I sign the form, I'm accepting your offer to insure. Answers given on the proposal are incorporated into the policy. You know this, you've insured your cars. Okay, you fill out a proposal, all of those answers get put into the... Why? Because the insurance company's managing their risk as well. Contracts for insurance are different from other contracts in one important respect. They are based on the principle of good faith and full disclosure. That is, truthful in all aspects. Good faith and full disclosure. And unless you complete a proposal with good faith and full disclosure, your insurance will be invalid. So when it comes to the claim, it goes down to the small print. Oh, you didn't declare that you were bankrupt 5 years ago. We're not going to pay. Why do they want full disclosure? It's so that the insurer the insurer assesses the risk. They decide whether or not to accept the proposal. So if you've been bankrupt in the past, that could affect your insurance. It might mean that your business is not very sound. Why is your business not very sound? Well, you know, you've had a whole series of catastrophes, accidents, disasters on your projects, okay, ran out of cash. So the insurance company has to assess their risk as well. So if you don't tell the truth, if you lie on the proposal, you've immediately voided the policy when it comes to a payout, because they will go through it very, very carefully. And if it's a structural collapse, for example, a retaining wall falls over, they won't necessarily just accept your word for it. They will get in an engineer to review what you've done. Okay, so they go through it very, very carefully. So the insurance company assesses their risk. Contractual obligations. So there's a liability allocated to the contractor under the construction contract. And it may be substantial. The builder is accepting the risk and must cover their liability with insurance. So you're taking on this project, you cover your liability to finish that project through insurance. The owner wants the building. That's all they want. And so that's your liability as the contractor. I have agreed, you have agreed to build this house for me. So that's the liability. So the insurance company will take that on. Insurance also protects the owner to whom liability is owed when the contractor or builder accepting the risk is unable to discharge their obligation unless it has insurance. So, you know, I don't want to get left with a half-finished house. Right, so the insurance protects me as well. Minimum requirements for insurance are set out in the general or special conditions of contract, and we looked at these last time when I was here, NZS 3910, so it's section 8, and New Zealand Standard Conditions of Contract 2014, it's section 6. Those are the special conditions of contract that refer to insurance. Under the general conditions of contract, the contractor is required to produce evidence that they hold the insurance policies. So under your contract conditions, you've got to show evidence. And that's generally a certificate. You've got an insurance certificate. And the amounts and stuff might be set out in the contract. So public liability might be $5 million or $10 million. Those things are set out. And you have to demonstrate that you've got that insurance in place by providing the owner with certificates. In addition to insurance, there may be specific obligations on a contractor. So if any loss or damage occurs, the contractor is responsible for the works on the site. For example, contractor must urgently attend to any safety or environmental matters. So, for example, the retaining wall falls over. And you say, oh, that's okay, insurance, no problem. But it's very, very heavy rain like today. And the retaining wall was holding up a slope. And the rain is coming down the slope and is washing all the dirt away into the creek or the river at the bottom of the piece of land. Okay, so there's a huge amount of mud and sediment going into the river. That's your responsibility. You've got to deal with that, okay, as an urgent matter, environmental matter. So you have to carry out work to prevent that happening. Or if the building is unsafe, you have to undertake work to make it safe. So the insurance is one thing, but your responsibility to undertake actions for urgent matters is another. So you just can't stand back and say, oh, just leave it to the insurance. You still have responsibility for the site. So there are a number of types of insurance. So the top one there is contract work insurance. And sometimes that's called all risks, builder's all risks policy. It's better, in my view, to separate these things and have a contract works insurance policy. This covers all the work on the project. The other is public liability insurance. What's public liability? That's the responsibility to another party. So a contract has two parties, you and me, two parties. But here's a third party who suffered injury or damage. So that's a member of the public. So you have public liability insurance to cover that third person. Professional indemnity insurance. I think I've got explanations for these things. Let's go through. Contract works insurance covers all risks normally associated with a construction project. Things like fire, theft, vandalism, natural disaster. Those are things covered under your contract work, but it only applies to the contract. So, for example, if you are doing a house renovation, your contract is to add 2 new bedrooms onto the side of the house. So the contract work insurance covers those 2 bedrooms and the work associated with that. But the crane falls over and damages the other side of the house. The other side of the house is not in the contract. The contract works insurance won't cover the damage to the other side of the house. That's third-party insurance. That's public liability insurance, because that's not part of the contract that we have. You just happen to be the owner, but it's not part of the contract. It's a third party. You become a third party to that accident. Oops. So, contract works covers unforeseen loss or damage only to the contracted building work. That's what I've just said. Doesn't cover the other side of the house, only the side that you're working on, the contracted work. Covers removal of debris, okay, so demolition, dismantle, demolish, remove debris, undamaged material necessary to effect repairs, stop further damage. So it covers making good. Generally covers building work while property is in transit in New Zealand. So if you've bought something and it's in transit within New Zealand, okay, that's to go on to that contract, and it gets lost or the truck tips over, all the stuff is damaged. Oh, I paid for that. How do I get it back again? Your insurance will pay for it. But it's generally only for transit in New Zealand. So not the case of what I talked about last time about supply chains from China. That will require additional insurance. So it can also be extended to include damage during the maintenance period. So you are responsible to undertake maintenance once the building is finished, and if something happens or is discovered during that period, it will be covered by this insurance. When does our session stop? When do we go home? 4:30. We'll just get through this and then we'll have a quick break. So public liability, that insurance covers loss to someone else's property. That is third party. So someone else's property, not your property, not the owner's property, covered by the contract. Covers unforeseen loss to owner's property not included in the building work. That's what I've talked about. Smashing the other side of the house. Professional indemnity insurance. This is generally standard insurance for consultants. It's the same thing as I talked about, a leaky home. Who do I sue? I'll sue the architect. Well, architects are like developers. They've got no money. Right, no point suing an architect. They've got no money. I'll tell you a joke. There was an architect who lived out in West Auckland in Titirangi. All right? And he won lotto. He won the jackpot. He won $10 million. And someone asked him, now that he'd won this $10 million, what was he going to do? And he said, I'm just going to keep working until it's all finished, until it's all gone. Right? So, architects don't make much money, all right? So, he was just going to keep working until all of his winnings had gone. So, architects, engineers will always have professional indemnity insurance. And what is it? It just simply covers errors and negligence by consultants or contractors. So if you make a genuine mistake, you just make a mistake, okay, it can be covered by professional indemnity insurance. And it covers litigation, so you're going to be sued, lawyers, you know. What do lawyers' rates start at? I don't know, start at $500 an hour. Not very expensive. So you've got to defend yourself in court. So professional indemnity will cover your legal costs. Construction plant and equipment. Covers a range of construction plant. Looked at the photos of the crane. Okay, very expensive piece of plant. Okay, you've got $200,000 piece of plant which has been destroyed. Okay, potentially that will disrupt your project. You have to hire a new one. That's additional cost. Who's going to pay? So the piece of plant is not covered by the contract. That's your piece of plant. It's not under the contract. And so construction and plant equipment insurance is a requirement. Sometimes this will be included as an extension if you take out an all risks policy. Okay. Covers loss or use or resultant damage. Strictly not an insurance from your perspective, but it certainly is from the owner's perspective, a performance bond. A performance bond will protect the owner against possible losses in case the contractor fails to perform or is unable to deliver the project. Okay, a performance bond. So you have put up, as the contractor, a financial bond. Okay, so if something catastrophic goes wrong, this money will be used to complete the project. And the only time you get that bond removed, or the money coming back to you, it's not money, it's only a bond, is when you complete the project. So this gives insurance to the owner that their project will be completed. Contractor defaults, declares himself bankrupt, then the bond surety is responsible for compensating the owner. So if on your project, so if you like, Arrow haven't gone bankrupt, they've gone into receivership. Okay. Mainzeal went bankrupt, but the amount of bond money on their projects wasn't enough to cover the job. We'll have a break there, last little section to go on employment law. So that's a very quick run through on insurance. So there's a lot of work, a lot of stuff here going through very, very quickly. but it means we get through it quickly. But maybe you've got some reading to do in your own time. It will take some time.